Hello, I am Dr. Manvendra Kumar Tiwari, and I work as an associate professor at the Dharmashastra National Law University, Jabalpur. Today, we will discuss in the legal reasoning part about the directive principles of state policy. The directive principles of state policy in the Indian Constitution is a unique set of principles which the Constitution of India embodies. Uh, it is said that it is actually inspired from the Irish Constitution, where such a concept existed at the time of framing of the Indian Constitution. And therefore, the framers of the Indian Constitution borrowed this idea from the Irish Constitution. Now, what is directive principles of state policy? Now, directive principles of state policy are those policies which work as a guide for the government of the day, both through the executive and the legislature, to realize the principles and promises envisaged in these principles. One unique thing about the directive principles of state policy is that though it is fundamental in the governance of the country, as it is stated in the Constitution itself, yet it is not enforceable in a court of law. Primarily because the framers of the Constitution also believed that though these principles are fundamental, nevertheless, the nature of these principles are such that that it can only be realized in a progressive manner, and primarily because there are budgetary implications flowing from the implementation of these principles, and therefore any policy which has a direct bearing on the public exchequer that should not be enforceable through the intervention of the court. And therefore, it was left to the executive and the legislature to realize the promise. Primarily, it is to be realized by the legislature by enacting laws incorporating these principles. However, we'll see that the courts, though have not directly enforced the directive principles of state policy, nevertheless, the pressing concerns embodied in these principles have, in a way, not kept the judiciary completely outside the confines of DPSP, and therefore they have intervened in their own unique way in the implementation of the directive principles of the state policy. Many of the important human needs like food, shelter, education is something that forms part of directive principles of state policy, and that therefore tells us that it is fundamental for a reason, because basic human needs are actually covered under the policies contained in DPSP, that is Part 4 of the Indian Constitution. However, again, keeping in mind the distinction that the courts exist to primarily enforce infringement of liberties and freedoms, and that is why non-access or lack of access to basic human needs is something that is not the subject matter of court, as has been envisaged in these directive principles of state policy. But we will primarily see that the march of human rights jurisprudence has actually incorporated within its fold basic human needs as well. And therefore, this distinction that the Constitution of India made between a right which is not a legal right and at the most a political right to be realized at the behest of the legislature, this distinction has often not succeeded in ensuring that the judiciary does not intervene in the realm of directive principles of state policy. And that is why we also very often find issues of judicial overreach, where the government of the day would argue that if the issues of food, education, and shelter are also to be agitated before a court of law like a legal right, then where lies the distinction where lies the realization in the DPSPs that these are subject to availability of resources, primarily financial resources. And that's why the mandate was for a gradual, progressive realization of these promises. And that's why to agitate this and for the courts to entertain such issues as petitions before the court of law is something which goes against the mandate of separation of powers as envisaged under the Constitution of India. So we'll see as to what are the significant provisions dealing with the directive principles of state policy in today's discourse. Now, if we see our Constitution, we find that in the Constitution of India, Part 4 of the Constitution of India contains Articles 36 to 51. That is around 16 around 16 articles which are there, and these articles are covered under the head Directive Principles of State Policy. Article 36 states application of principles contained in this part. This part is Part 4. The provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be duty of the state to apply these principles in making laws. So as we can see, the very first provision of Part 4 says that these principles, never though fundamental in the governance of the country, and it shall be duty of the state to apply these principles in making laws, yet these are not enforceable at the behest of any court of law. However, what is important to note in Article 36 is the fact that these principles are fundamental in the governance of the country. Article 39, certain principles of policy to be followed by the state. The state shall in particular direct its policies towards securing, Clause A, that the citizens, men and women, equally have the right to an adequate means of livelihood. So, adequate means of livelihood, ensuring that every citizen has adequate means of livelihood, is the responsibility of the state, and the state is duty bound to make laws which further this objective, and it is a fundamental principle. So it also tells us about it in a way guides the politics of the day as to what should be the goals which the politics and the political class must strive for. That now Clause B, that the ownership and control of the material resources of the community are so distributed so as best to subserve the common good. Now, this is talking about resources, because the resources in the community are limited, and often there is a mismatch. Some people have the access to the bulk of these resources, whereas the overwhelming majority has to deal with peanuts. And that is why this particular principle is asking the state to ensure that the material resources of the community are distributed as best to subserve the common good. Clause C, that the operation of the economic system does not result in the concentration of wealth and the means of production to the common detriment. Now, this is again ensuring that even the economic system must not work in a manner that few persons' wealth keeps on increasing. So it is actually insisting that the economic system must ensure non-concentration of wealth in the hands of few. So this is also an important caveat, and many therefore argue this to be an example of a socialist constitution where capitalism is being opposed. However, it remains to be seen as to whether this actually was the right understanding of this provision. Nevertheless, it clearly asks the state to ensure that the economic system does not operate in a manner that it results in the concentration of wealth in the hands of few, to the common detriment of others. this is an important amendment in Part 4 that was added by way of a constitutional amendment. Equal justice and free legal aid. The state shall secure that the operation of legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that the opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. So, this is a recognition that legal aid is an important objective, and many citizens, because of lack of economic resources, are unable to access justice at par with those who possess the economic means. And that is why Article 39, capital A, puts a duty upon the state to ensure that everyone, irrespective of the economic means, must have access to legal aid. This is a very, very important provision. There is a lot that remains to be achieved in order to realize the promise of this directive principle of state policy. Likewise, Article 41 of the Constitution, which talks about right to work, to education, and to public assistance in certain cases. It says the state shall, within the limits of its economic capacity, as you can see, all these are within the limits of economic capacity. So that's the reason why these are not enforceable primarily at the behest of the court. Because if it is subject to the limit of the economic capacity, then the existence of such an economic capacity is left to the wisdom of the government of the day. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. So, what it very categorically is highlighting is securing right to work, to education, and public assistance in case of unemployment. And as you can see, the Supreme Court of India in Mohini Jain versus State of Karnataka has actually declared right to education to be a fundamental right, flowing from which flowed primarily from Article 41. Though this is an amended version of Article 41, the unamended version, the original one, has actually articulated that right to education and right to primary education in between 6 to 14 years of age of a child, that must be achieved within 10 years from the commencement of the Constitution. And that is why the Supreme Court obviously was unhappy about the fate of that promise, which was time bound in the Constitution of India, that in 1992 also right to education, and that to primary education, has not been realized, which was supposed to be in the year 1960. And that is why the court, doing a progressive interpretation, stated that education is something which cannot be considered as not falling in right to a dignified life, and dignified life ought to have access to basic human needs. And following this logic, the court actually read right to education under Article 21 of the Constitution of India. So that is what I was initially talking about, as to how the distinction between the enforceable rights and non-enforceable right has not been very watertight. And over a period of time, especially because the march of the human rights jurisprudence globally, basic human needs related rights have actually found judicial articulation as enforceable rights, though the courts innovatively has actually read it as part of interpretation of the enforceable fundamental rights. Like in this case, the court read that right to life must mean right to education. If there is no education, the right to life is not guaranteeing, ensuring a dignified life, and therefore a right to education must be read as part of Article 21. Subsequently, in the year 1993, the Supreme Court in Unnikrishnan versus State of Andhra Pradesh actually restricted the ambit of right to education as as encapsulated by the Supreme Court in Mohini Jain, and the court in this case said that right to education only up to primary education can be a fundamental right. So university education, even education beyond primary education, the court said that remains subject to the limits of the economic capacity of the state, and therefore that cannot be covered under Article 21. So Uni Krishnan actually restricted the ambit of right to education falling within right to life. And subsequently, as a consequence, by way of 86th constitutional amendment, uh, Article 21 capital A was added into the Constitution of India, guaranteeing a right to primary education for children between the age group of 6 to 14. However, again, this promise was only realized in the year 2009 by the enactment of the Right to Free and Compulsory Education Act 2009. So that's the saga in brief of the right to education, which actually flowed from Article 41 of the Constitution of India. Now, this is a very controversial, debatable subject matter. Article 44 of the Constitution, Uniform Civil Code for Citizens. We know that in India, when it comes to the personal laws, that is the laws that relates to marriage, divorce, guardianship, succession, uh, adoption, these issues are still dealt with by what is known as personal laws. And in personal laws, we have two set of laws, one which are actually laws enacted uh, through the legislature, and the second set of laws are the religious uncodified laws, which primarily flow from the holy religious texts of the different religions like Hinduism and Islam. So the fact that these uncodified personal laws in many areas where the codified personal law does not exist is still the law of the land, uh, results in the laws being unjust on many counts, and primarily on the yardsticks of gender. So the gender justice remains one of the primary concerns of reform because of the acceptance of the uncodified personal laws as laws. So Article 44 of the Constitution has realized this problem, and therefore it left it to the governments of the future day to ensure that these disparities that exist in the personal laws because of the separate religious personal laws are taken care of by way of a uniform civil code. However, the debate remains to be settled whether uniform means one or uniform can also mean various laws, yet the laws are laws being just. So the issue is whether do we need to do away with completely Hindu, Muslim, Christian Parsi laws, or can we continue with Hindu, Muslim, Christian Parsi laws and ensure, by way of enacted laws, that these laws, in the name of plurality, are not unjust. However, the primary purpose of Uniform Civil Code uh, remains the quest for justice, to ensure that injustice that is being tolerated by the Constitution because of the existence of various personal laws, that injustice is taken care of. However, it's been 74 years, and yet the promise remains unfulfilled. A lot has been done by enacting separate legislations, but there are several issues that still remains to be covered, and that is why Uniform Civil Code remains a subject matter which is very often a very contentious political issue. So this is what Article 44 is. Next, we have Article 46, promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. That's again a very important provision, primarily talking about scheduled caste and scheduled tribes and other weaker sections. The state shall promote with special care the educational and economic interest of weaker sections of the people, and in particular of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. So this is one of the very important principles contained in Part 4 in Article 46, primarily catering to the needs of scheduled caste and scheduled tribes and other weaker sections because of the historical injustices that have been perpetrated against these groups. And that's why the Constitution is aware of this and therefore puts an obligation on the state to ensure that their interests get special attention of the state, and they're always protected from the social injustices and all forms of exploitation. Article 47, duty of the state to raise the level of nutrition and standard of living and to improve public health. So that's again a very important provision. However, there is also a very contentious issue related with Article 47. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties. That's perfectly fine. Raising the level of nutrition, standard of living of its people, and improvement of public health as among its primary duties. And in particular, the state shall endeavor to bring about prohibition of the consumption, except for medicinal purposes, of the intoxicating drinks and drugs which are injurious to health. Now, the second part says the state shall endeavor to bring about prohibition of consumption, except for medicinal purposes, of the intoxicating drinks. So, intoxicating drinks would include whiskey, wine, beer. Now, if we go by the mandate of Article 47, what we call sharab in general, these are to be used only for medicinal purposes. Now, in contemporary times, these are huge sources of revenue for the states. And whether the states, therefore, can muster the courage to actually follow the mandate of Article 47. There are few states in India which have banned liquor in all forms. States like Gujarat and Bihar. But barring some of these exceptions, in all other states, liquor, sharab is freely available, and the government is earning a huge source of revenue from the sale of these intoxicating drinks, which are injurious to health. So this also, in a way, gives rise to a moral conundrum, whether the state should actually interfere and ban intoxicating drinks. I'm not talking about drugs, but intoxicating drinks. Should it be banned? Should the state do that, or is it something that should be left to the individual wisdom of human beings who want to or not, whether they want to use these intoxicating drinks or not? And that's why this is a debate which comes up every now and then when the issue of banning liquor comes up following the mandate of Article 47. Not similar, but there is also a provision which is equally contentious, that is there in Article 48 of the Constitution of India, which provides for a ban on slaughter of cows primarily. And there are some states in India where Article 48, which provides for a ban on cow slaughter, that is not enforced. So the mandate has not been acted upon in states like Kerala, states like Goa, and northeastern states. And this also remains a contentious issue. So it is argued that some of these provisions were contentious, and that's why to read a provision like Article 47 or a provision like Article 48 along with Article 36 which says that all these principles are fundamental in the governance of the country, many say is not the correct contextual reading of the circumstances in which some of these DPSPs were actually included in the Constitution of India, and that within the Constituent Assembly also there was a class which demanded some of these things to be included in the Constitution, and therefore their inclusion in DPSP was a kind of compromise settlement that was reached between people who wanted that these should not form part of the Constitution, or and between the people who wanted these to be included within the Constitution. So by including it in DPSPs, so the inclusion was done, but by the fact that these are subject to the will of the state, therefore, in a way, the actual implementation of these principles was also postponed to a future date. So that's the many argue that this is a kind of compromise. A professor from London School of Economics, Professor Tarunav Ketan, has written a wonderful article on this, where he has further highlighted as to how some of these provisions were actually a compromise among the people who were at loggerheads in the Constituent Assembly of India while framing the Constitution of India. Article 48A, again included by way of a constitutional amendment. Protection and improvement of environment and safeguarding of forest and wildlife. The state shall endeavor to protect and improve the environment and to safeguard the forests and the wildlife of the country. So this is about environment, forest, and wildlife. And we'll see that the Supreme Court, for example, in these cases, MC Mehta versus Union of India and MC Mehta versus Kamal Nath, and even in some of the other cases, the court has actually invoked Article 48A to adjudicate. So that again tells you that though these are not enforceable, nevertheless, an interpretation which is in line with the principles of Part 4 has always been preferred by the courts led by the Supreme Court of India. Article 50, separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in the public services of the state. Now, this was primarily because in 1950, when the Constitution started operating, many of the judicial functions were actually performed by the executive. And that's why there was this mandate to ensure that if judiciary as an organ has to remain independent, then first of all, the judicial functions must be assigned exclusively to judiciary. And that's why this Article 50, an important provision. However, we also have to keep in mind that over a period of time in the recent past, there has been, in a way, flood of there has been a lot many tribunals that have been constituted by legislations. And one of the attributes of these tribunals are that the judges in these tribunals, apart from the ones who are or who have been judges, these tribunals are also manned by people from the executive who possess experience of the field, and that's why many say that the tribunal is also a kind of the constitution of tribunals brings this conflict between what the state is trying to do and the mandate of Article 50. And finally, promotion of international peace and security. So this is in Article 51. The state shall endeavor to, this is about international peace and security, promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations. So that's important. One of the DPSPs is to ensure that there is respect for international law and treaty obligations in the dealings of organized people with one another. And finally, encourage settlement of international disputes by arbitration. So that's also important, that you settle international disputes by way of adjudicatory means, arbitration. Go for arbitration also is one of the messages coming from the Constitution when it comes to resolution of international disputes. Now, we have this apart from Article 36 to Article 51. There is this provision, Article 31 capital C, which refers to principles of Part 4, and that is why it has been covered in today's discourse. Article 31C says, saving of laws giving effect to certain directive principles. And it reads, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Provided that where such a law is made by the legislature of a state, the provisions of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. Now, if you look at what is written in the blue portion in the italics, declared unconstitutional in Minerva Mills 1980, and Ishwanand Bharati, Keshwanand Bharati, 1973. So, respectively, that means the first part, that is all or any of the principles laid down in Part 4, this part was declared unconstitutional in Minerva Mills. And the second part, that is no law containing a declaration that it is for giving effect to such a policy, this part was declared unconstitutional in Keshwanand Bharati in 1973. Now, if we look at the legislative history of this provision, as it is visible in this slide, was the version of Article 31C that came into the Constitution after the 42nd Constitutional Amendment. So originally, Article 31C was inserted into the Constitution of India by 25th Constitutional Amendment. And in the 25th Constitutional Amendment, the first part, which is in italics, that is all or any of the principles laid down in Part 4, at this place it was written, securing the principles mentioned in Article 39B and 39C. What 42nd Constitutional Amendment did, that it gave primacy to entire Part 4 over Article 14 and 19, whereas the 25th Constitutional Amendment version of Article 31C had only given primacy to two clauses of DPSP, that is 39B and 39C, over Article 14 and 19. That is primarily to ensure that if there is a legislation meant to ensure that there is no concentration of wealth in the hands of few, that the material resources of the community are so distributed so as to subserve the common good, there should not be a challenge to that legislation on the ground of Article 14 and 19, resulting in a declaration of unconstitutionality by the court. Now, this version of Article 31C, that is the 25th Constitutional Amendment version of Article 31C, was declared constitutional by the Supreme Court in Keshwanand Bharati. However, the second part of Article 31C, which is there in italics here, that no law containing a declaration that it is for giving effect to such policy shall be called in question on the ground that it does not give effect, this question shall not be inquired into by the court. The court in Keshwanand Bharati itself declared it to be unconstitutional. That means that if a legislation is claiming that it is giving effect to the principles of 39B and C of the Constitution of India, mere declaration would not suffice. The court can examine whether the law is actually doing that or not. The fact that Article 31C precluded the courts from doing so, this portion was declared unconstitutional by the Supreme Court in Keshwanand Bharati. Now we'll see a few questions. Directive principles of state policy are justiciable, no. Not justiciable appears to be right. Partly justiciable, no. None of the above. Not justiciable in a court of law. Directive principles of state policy have been inspired from the Irish Constitution, Clause D. Right to primary education is a both fundamental right and statutory right, because the 2009 right to education law is now there. So option D is the right answer. Right? Food is a fundamental right, DPSP, statutory right. I did not mention this while discussing the provision which talks about nutrition. This again has happened that the court has, the Supreme Court of India, primarily in PUCL, People's Union for Civil Liberties, PUCL versus Union of India, has declared right to food also to be a fundamental right flowing from Article 21, that is, right to life, or to have a right to access to basic human needs, and food is a basic human need. And consequently, there is a Food Security Act now that has been enacted by the Parliament of India. So therefore, right to food also is a fundamental right and statutory right. So therefore, option D, both A and C, is the right answer. Respect for international law is a DPSP, not a fundamental duty, not a fundamental right. It's a directive principle of state policy given in Article 51 of the Constitution. In respect of DPSPs, the court can enforce it. No, the court cannot enforce it. The court may prefer an interpretation which furthers DPSP. These are enforceable. So option C, the courts may prefer an interpretation which furthers DPSP. A public interest litigation involving environmental concerns cannot be entertained, can be entertained, must be entertained. It's can be entertained, must, because it takes away the discretion. So option C cannot be the right answer. Option B, can be entertained by the courts. Again, tells you the impact of some of these DPSPs and also the conflict that it gives rise to on the arguments of judicial overreach. But public interest litigation involving environmental matters, concerns can be. And the courts on many occasions in India have done that. Article 31C after 42nd amendments gives primacy to entire DPSP over Article 14. Yes, so option C is the right answer, but this was declared unconstitutional in Minerva Mills. Article 31C was first inserted by 25th Constitutional Amendment. Option C. The first half of Article 31C is constitutional as it existed after the 25th, because the 42nd Constitutional Amendment version has been declared unconstitutional. And that's why the version that was inserted for the first time by the 25th Constitutional Amendment is the one which is constitutional. Thank you very much.